Guys, welcome back again to my channel. It's your boy Kiz1 and I'm here with a wonderful headline. But before that, if you are new here, please subscribe and like my videos. Let's get down to it. So Nnamdi Kanu's lawyer accuses Tinubu others of violating Nigeria Supreme Court bail order on IPOB leader because they gave an order that Nnamdi Kanu is free from every charges that was charged against him by another government, but the government are going against the court order. Then imagine if our government are going against court order, what do they expect from others to do? Because I don't see a reason why court will pass an order and then the government are meant to be respecting the order is going against it. Same thing goes to the DSS office that went against court order that said that Nnamdi Kanu's lawyer had the right to grant Nnamdi Kanu for 3 times a week, Monday, Wednesday, and Friday. But DSS denied access for Kanu's lawyer to come meet Kanu. Imagine our leaders that are violating rules and regulations and court orders. How did I expect us that are normal Nigerians to now do? But let's get down to the articles. So Barrister Aloy Ejimako, Special Counsel for the detained leader of the IPOBs, Nnamdi Kanu, has accused President Bola Ahmed Tinubu, Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, and the Federal High Court of blatant violation of court order and constitution in Kanu's case. Ejimako said Tinubu, AGF, and the Federal High Court's failure to restore Kanu's revoked bail as ordered by the Supreme Court in 2023 is a blatant violation of the order of the Apex Court, 1999 Constitution of the Federal Republic of Nigeria and international laws. Ejimako recalled that in December 2023, the Supreme Court held that it was wrong to have revoked Kanu's bail, meaning that his bail should, without delay, be restored by virtue of Section 287, Subsection 1 of the Constitution. So, Section 287, Subsection 1 of the 1999 Constitution states, the decision of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons, and by courts with subordinate jurisdiction to that of the Supreme Court. So the law, by our constitution, it states that the words or the judgment of the Supreme Court is final and must be obeyed by every authorities in Nigeria. But imagine barely God's common DSS office is going against that law. And that government is going against the same law. And then you call Nigeria a civilized country, and then you call Nigeria a country that has constitution, whereas our leaders cannot follow and obey those instructions given in the constitution. Because I read again that Section 287, Subsection 1 of the 1999 Constitution states, the decisions of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons. By all. There was no exemption here. They said by all authorities and all persons, and by courts with subordinate jurisdiction to that of the Supreme Court. So I continue. Ejimako said the operative part in the constitutional provisions lies in the phrase that says by all authorities and persons and by the courts. That means any other court lower than Supreme Court must obey the judgment of the Supreme Court. But in Nigeria, the High Court are still charging Nnamdi Kanu and trying him, whereas they've given the judgment from the Supreme Court that he should be discharged of every charges placed against him. So he said, it follows therefore that since the Federal High Court refused to enforce the decision of the Supreme Court by its inexplicable failure to restore Nnamdi Kanu's bail, the federal government, which is an authority, or President Bola Ahmed Tinubu or AGF Fagbemi, who are in persons, can step in and restore Nnamdi Kanu's bail. And they are all bound to do so without more, because by the clear provisions of the Constitution, they do not need any further court order. In other words, it does not lie with the court alone to enforce the decisions of the Supreme Court. The President or the Attorney General can also concurrently exercise the same power. To be sure, their collective refusal to act has unwittingly turned Nnamdi Kanu to a victim of force or unlawful imprisonment by Nigeria state. This is where Britain comes in, because Nnamdi Kanu is also a citizen and under British law and pertinent international law binding Nigeria and Britain. No British citizen should be detained illegally by any country regardless of dual nationality. Do you see that Nnamdi Kanu has backings? it's just that those backings don't to start acting, because if they start acting now, it's going to be a very huge problem for Nigerian government, because the British government have the right now to step into the case and say that Nigeria must release its citizens, because Nnamdi Kanu is also a British citizen, and by their law say that nobody, no law should illegally detain any of its citizens. But why are they keeping quiet? I don't know about that yet. So it's my question: is this lawful or constitutional for the president and the Attorney General of Federation, who breached the constitution by refusing to enforce the decision of the Supreme Court, to turn around and insist on subjecting Nnamdi Kanu to a trial before a federal high court that also violated the constitution by refusing to enforce the same decisions of the Supreme Court? He stressed the answer is obvious, and that is, it is a blatant violation of Section 287, subsection 1 of the Constitution. It is what? Unlawful. It is perverse. It also offends the basic canons of equity and good conscience, and it is immoral to boot. So I continue reading. Ejimako emphasized that equity requires all to have clean hands, stressing that the trial of Kanu no longer bears any clean hand. Because how can the Supreme Court give an order if Federal High Court is violating that law? Nigeria government, the same thing. AGF, the same thing. DSS, the same thing. That means our country is not governed by any law or any constitution. Because since our leader cannot follow that constitution, that means Nigeria is constitutionalist, if that English is correct, by the way. So I continue. According to him, this is because the authorities, the president and the AGF, that prosecute him and the Federal High Court that designs to try him brazenly dishonored the Supreme Court and the Constitution by refusing to restore his bail. He questioned, how can you subject a man to get recourse and travails of prosecution and trial under a constitution you flagrantly violated in its black letters and spirits? And is Nigeria under a rule of law or rule of impunity, whims and caprice? This is close of the matter, because I don't see reasons why they should be holding Nnamdi Kanu still in detention till today. After Supreme Court, which is the highest court, are giving a judgment that Nnamdi Kanu should not be bailed or tried in any court. But the government is still taking Nnamdi Kanu to Federal High Court to do what? That means that we in Nigeria, we don't have any constitution guiding us. We don't have any rule of law guiding us, since our leaders are violating that. So this is the state of the matter right now, because if they keep on keeping quiet, this our government will be doing as they wish. And thank God that the lawyer have started calling out even the British government to come and help them. Because in this case now, they need help from outsiders. And guess what? Even the US will still put hand, the British will still put hand. That means it will be a fire force to Nigeria government. So I think they should start acting by the rule now, before it is too late. So I'd like guys to end the video you've watched in the comment section. If you are new here to my channel, please subscribe. I will see you guys in my next video.